Okay, great. I think we've hit a critical mass, um, and I think we can get started. Um, my name is John Penny. I'm a professor here at Osgoode Hall Law School in Toronto, and I'm absolutely thrilled to welcome Professor Ari Ezra Waldman to Osgoode Hall Law School community, New York University community, to talk about his brilliant new book, Industry Unbound, the inside story of privacy, data, and corporate power. It's based on countless interviews with technology company employees. He takes us inside Silicon Valley, inside technology and information industry, to offer an unprecedented look, an account, and insights as to how these companies are, and why these companies are undermining privacy. Now, before I get into Professor Waldman's biography, I thought it's also personally gratifying to welcome you as well. The other day I was thinking back when we first met, and I think if I recall, I know we were both doctoral students. It was likely at one of Eric Goldman's Internet Law Work in Progress conferences in Santa Clara, maybe 2012, 2013. Anyways, that's too many years ago, I think. The point here is that it's been great to see your award-winning work evolve over the years and to learn from you. And I know you're in high demand, and so I personally appreciate you for taking the time to join us for this conversation about this book, which I think is going to be a foundational privacy text. Okay, so a bit more about Ari. So Ari Ezra Waldman is professor of law and computer science and faculty director for the Center for Law, Information, and Creativity at Northeastern University. He researches the ways in which law and technology reify traditional structures of power, with particular focus on privacy, law and society, civil rights, and the LGBTQ+ community. He has written 2 books and published nearly 30 scholarly articles in leading law reviews and peer-reviewed journals, and has also won numerous awards for his scholarship, including twice winning the Best Paper Award at the Privacy Law Scholars Conference, and recently was named one of the world's top 20 thinkers by Prospect magazine in the UK. He is an affiliate of Yale Law School's Information Society Project, a former Balfour Fellow of the Center for Technology and Society at the Anti-Defamation League, a member of the board of directors of the Cyber Civil Rights Initiative, and an advisory board member of the Electronic Privacy Information Center. He's also founder of Legally Queer, an Instagram-based project educating the public about law and the LGBTQ history and current events. He holds a PhD in sociology from Columbia University and a JD from Harvard Law, and an AB magna cum laude from Harvard College. So before we begin with our conversation, just a little bit of housekeeping for the audience, and thanks as well for everyone who's joining us for this conversation on this Thursday afternoon. Ari and I will be in conversation for about maybe 30, 40 minutes, and we'll move into Q&A. And the way we'll do that is we'll ask participants to drop questions, write their questions in the chat channel, and I'll moderate. I'll grab some questions that are there, identify the questioner, provide context where necessary, and relate those questions to Professor Waldman. Okay, so let's begin from the top. And thinking about the context today with the Facebook papers and similar leaks and Facebook whistleblowers, Ari, maybe the context provides an answer to this question, but I'd love to hear your thoughts on it in any case. Why this book project? Why this book, and why now?
Thanks, John. Well, first, thanks so much for having me for that overly generous introduction. I feel grateful to have this opportunity, not just to speak with you, but to your students. And I hope everyone at the Osgoode Hall community is super excited, as excited as I am that you are there and that you are part of this community and contributing your outstanding and groundbreaking ideas to this wonderful scholarly group. So why this book? Well, there are a ton of reasons, but I'll just highlight 3 very quickly. First, the literature in this space was woefully incomplete. There a number of scholars over the last I'd say decade had wanted to see what privacy law was looking like on the ground, and a couple of them actually published a book called Privacy in the Books and on the Ground. And yet that work, although important to understand the ways chief privacy officers were trying to integrate the law into their work, incompletely painted an incomplete picture of what privacy law looked like inside a company, right? You don't just talk to the person in charge or the person that's in charge of painting a rosy picture, or the PR or the outward facing work of the company, right? You talk to the people who are on the ground who are actually doing the work. To suggest that technology companies were integrating privacy into design because the chief privacy officer said that they were training professionals in each business unit to be experts on privacy says nothing about how engineers are actually integrating privacy into the design of their work, says nothing about the effectiveness of those privacy officers that they're hot training or hiring. So that's one reason. The literature was incomplete. A second reason is that talking about the law generally as it's written is always incomplete, because we can write any law we want, but if we allow the people who are supposed to be regulated, or the companies that are supposed to be regulated or limited by those laws, to manipulate, to co-opt, or if we allow the agencies that are tasked with public governance and enforcement to not do their job, then what's the point of passing a law, right? So I wanted to see how the law that a lot of privacy law scholars talk about actually works. And then a final reason is because our privacy is remarkably and unendingly at risk. And we live in this world, right, especially now, where so many people are telling us that there's privacy law everywhere. The European Union is recently passed and enacted a comprehensive privacy law called the GDPR, which everyone is calling the most strict and the best privacy law in the world. You have states like California, Colorado, Virginia, that are Massachusetts, that are passing or thinking about privacy law. You have Canada, which is considering its own privacy law. So we're in a world of lots and lots of privacy law, but our privacy isn't actually getting any better. We're still getting new products that are defaulted to surveillance. We are still in a world where any company can seemingly take every single picture that exists on the internet and create a facial recognition system that they can sell to the highest bidder. We're still living in a world where lots of people think that privacy is dead because companies are making these arguments that no one has any privacy anymore on the internet. So I wanted to figure out, well, why is that the case? How can people be telling us that we have all this privacy law and no actual privacy?
Okay, that's a great canvassing. I think it leads nicely into my next basic question. So you've nicely set up the case for why this book and why now. You're absolutely right. We are living in a world with a lot of privacy, but it's largely inadequate. So what's the core argument of your book, and what are you aiming to do with this project?
So the book argues that companies strategically use their organizational structures to co-opt both the law and their employees, the people inside the companies that are tasked with implementing and ensuring compliance with the law. And the way they do that is, when I say organizational structures, I mean anything from how work fits into the larger company, to reporting procedures, to how management works, to how teams interact with one another, to where people sit in the physical building, like anything about the internal corporate structure. And these aren't just companies that just say, okay, well, here's a law like the GDPR that requires me to do privacy impact assessments and keep records and hire officers. They're not just doing that. They're integrating these requirements into an organizational system that is specifically designed for profit. And what they do is they end up co-opting both the law and the people tasked with implementing the law, such that the people who, even those that call themselves privacy advocates, don't even realize how their work is perpetuating or supporting data extractive behavior. So the conclusion that I make from this ethnography is that in some cases, these strategies that span lots of different companies create a sense of false consciousness among privacy professionals, privacy lawyers, engineers, privacy engineers, such that they don't even realize that they are foot soldiers in a larger data extractive campaign.
Okay, I love this use of the term false consciousness. We're gonna come back to that. I want to unpack that phraseology or that term a little bit more in just a moment. But you mentioned there, and before we get too far deep in the weeds on some of your insights, I'm going to ask you some examples of what you're talking about in just a moment. But I think one of the great contributions of this work, and of your work more generally, is how you combine your training in sociology and in social science methods and in social theory with your expertise in privacy theory, right? And what you do in this book, in Industry Unbound, is you provide this you draw on those that training, that interdisciplinary capacity, and you combine them and synthesize them, and you provide this on-the-ground picture for what's happening inside these industries. So maybe it would be great, I think, because one of the great contributions and the great parts of this book is the richness of your methods. This is not just a privacy law book writing about what's on the text and critiquing the reforms that are happening around us. You're providing these kinds of insights. So if you could tell us a little bit more about your methodology when you say ethnography for some of the students on the call, what does that mean? And maybe give some examples of challenges that you encountered in doing this work.
Great question, and thank you for asking it. In many ways, my integration of sociological methods, both qualitative and quantitative, is inspired by your work too, which integrates social science and quantitative methods in understanding the law. I remember when I first, just as an aside before I actually answer your question, when we first met, you were giving a talk about your dissertation about chilling effects, such that I said to myself, oh, I wish I had done this, right? Such that it was such a good integration of quantitative methods, sociological tools, and understanding the law. But in any event, so what I did was I wanted to, in order to see what was going on inside technology companies, you can't just send out a survey. And the goal was not, nor was the goal to identify a random sample of people, because who is the sample? Like, I'm not talking about users. This is a hidden community. These are people that are really hard to access. Getting inside a company is really, really difficult. So what I was able to do through various contacts, through cold call reaching out, and through meeting people at privacy professional conferences as well as engineering conferences, is I had the opportunity to be embedded inside 3 technology companies, and they were at the time, these are medium-sized companies, and they were at the time working on various technological products. I signed confidentiality agreements as to their actual products and actual proprietary information, because this book isn't about a particular app, it's about their processes. So being embedded inside a company for a certain amount of time, you're able to sit inside meetings, take notes, follow people to their desks, see how they work, interview people, and so forth. But the companies that refused to do that were, of course, the big tech companies, Facebook and Google and so forth. And a lot of these companies had demands that they have posed and put on other academics, but some of those academics have refused, but some of those academics have acceded to their demands. Those demands, however, things like pre-approval of all quotes from company officials before publication, or only talking to representatives of companies on deep background and not quoting anyone, allowing companies to have that, allowing your research subjects to have that kind of control over your research is a violation of research ethics. So I didn't accept their terms. But in order to get at what's going on inside these companies, then I had to talk to current and former employees on a more informal basis. So that's what I did by going to these conferences something what we call interface ethnography, where sometimes these companies have, they'll invite members of the public or members of civil society and the academic community to presentations from these companies about what's going on in AI, what's going on in privacy. And they're usually governed by Chatham House rules, which is you can quote, but you can't attribute. But as for those who have seen the book, I worked with everyone that I spoke to come up with a pseudonymous description of the person, former employee of this, project manager at this type of company, so they could speak freely. So the fact that I couldn't attribute to any one particular person was immaterial. So in short, what I had to do was combine a lot of different methods. As a result, what this story is it's not about every single company. Right? I'm not saying that every strategy or every tactic that I describe exists at every company, because that's not what qualitative research does. I'm teasing out that these strategies do exist, and here's how I saw them, and here are the consequences of these strategies. And in most cases, the consequences of these strategies is to prevent privacy from gaining a foothold in the design process.
Okay, that's a perfect segue into where I'd like to go next. So, I mean, part of why I wanted to have you say a few, a little bit about your methodology, because I really think it provides really some great insight, for those listening in and those, who have not yet gotten the book. I highly, highly recommend it. Understand the amount of research that went into this, and one of the significant contributions of this book is this kind of difficult ethnographic work that you've done, which I think really makes the argument of the book powerful and compelling, that you have been there, you have spoken, you've given that on the ground insight. So you mentioned just a moment ago these strategies that these companies engage in. And then earlier you mentioned this notion of false consciousness. Tell us a little bit more about these strategies. How do these companies create this false consciousness? What is it and how do they create it?
Great. So really excellent question that dives right into, I think, the main contributions of the book. And unfortunately, I mean, there are tons of these strategies, right? So that's all throughout the book. I'll give you just a couple of examples with real stories that come from the research. So what do I mean by false consciousness? So the idea of false consciousness is a Marxian Gramscian idea that has been used to describe the lack of consciousness among workers or among individuals that they are being subordinated by a capitalistic system. They have this false consciousness, right? Lack of awareness. So I use the term to describe the lack of awareness, wittingly or unwittingly, awareness among workers, particularly those that call themselves privacy advocates and see their role inside companies as advocating for privacy, and abject unwillingness to recognize that what they're doing is the opposite of privacy advocacy or the opposite of improving privacy for consumers. So it's a sort of cognitive dissonance where someone will call themselves a privacy advocate and say that I'm the representative, I am the consumer representative inside this company, I am doing all this work on your behalf, and then proudly describing all of the things that they're doing, and yet none of the things that they're doing are protective of privacy. So that's what I mean by that concept. So I'll give you some examples. So one way that a company can habituate their privacy professionals into thinking they're doing pro-privacy work, but in fact are not, is to limit and to limit the kind of work that a privacy department does. So one of the things that you learn really quickly by going inside these companies is that privacy departments are so busy. They're doing a lot of work. And that's unusual, right? Especially compared to 5-7 years ago. If all you did is stop there at how much work they're doing, you would be inclined to think, oh, well, the privacy department is doing a lot of work, it must be having an impact. But then look at what the work they were doing. Whereas a department will say, oh, look at all this work product that we created over the last 6 months, new policies, new trainings, new impact assessments, reports, new discussions with engineers and so forth. And then when you look at them, they're all about transparency and they're all about choice. And as anyone who has taken a privacy 101 class knows, is that no one's privacy is going to be improved by making privacy policies more readable. The last time any of us read a privacy policy was literally never for most of us. And by adding on, by making more, creating more toggle buttons inside an app or on a website, that's not going to materially change the world. It's not going to materially change our privacy. And yet, in this one situation, like everyone in the privacy team was like, look how busy we are. Look at all this work that we're doing. And then when I asked them, well, how are you having an impact? And then they said, well, look at how many more choices you have. Look at the impact assessments that engineers are filling out. Look at our privacy policy. And then when I asked, well, how has that changed the privacy impacts of your products? And there's like, well, what do you mean? Like I don't understand the question. Like, we're improving our privacy policies, right? So people have become, by their bosses giving them only a certain type of work, which is a focus on transparency and choice, they become habituated into thinking that that's what privacy law is, that there's no concept, that any other version of what privacy departments could do is completely nonsensical. Another example, I spoke with a lot of departments, a lot of companies where each company was saying that, oh, well, I have that there is a lawyer that's dedicated to a product, especially a big company. You'll have lots of different privacy lawyers and they'll be tasked on a particular product, right? So they're their advisor. But what a company will do is it will limit what the privacy lawyer can do in the design phase. So they'll brag to the world and brag to researchers that only limit their research to the top level, to the C-suite. They'll brag that, oh, we assign privacy professionals and privacy lawyers to all of our products. Great. But then they use their corporate hierarchies and reporting structures to literally prevent the lawyer or the privacy professional, the privacy expert, someone ostensibly more capable of spotting privacy issues in design, from affirmatively working with the engineering team. Instead, the engineering team has to raise the issue. So the result is you have an engineer who's probably not trained in privacy, except for maybe a 30-minute onboarding video about the importance of privacy, who first has to spot the issue, and they're going to miss most of them. And if they spot an issue, then they're going to take it to their manager, who is a former coder, and they're going to take it to their manager, who's a former coder, and they're going to take it to a product manager, and then only then will the product manager maybe take some of the issues to a lawyer in a specially designed meeting. And what this does, though, is the repetition of this kind of stifling reporting process makes people think, well, that's what we do. Like, there's no other option, right? That's what privacy is. Our consultation, a lawyer in this context said, well, what would you have me do? Sit in the design meeting and help them? And I'm like, yeah, why is that such a big deal? So, oh, well, that's not, I've never thought of that, right? How is it possible that someone who calls themselves a privacy advocate and who described their job as spotting privacy issues in the design process would never have thought of sitting in on design meetings to help engineers spot privacy issues? Well, because they have been habituated by the structures and organizations and structures and habits of their company into thinking that, well, this is what I mean by that, right? So there are tons of other examples. Some are completely wacky, including general counsels storming out of rooms when I asked them about briefs that they actually wrote and how that doesn't accord with the things that they were saying to me, or situations where engineers are habituated into thinking that, well, someone else is dealing with privacy, so that's not my responsibility. But with all those examples, we'd be talking until midnight tonight.
I mean, that's really one of the really enjoyable parts of the book are the little snapshots of conversations that you provide, which really are mind-blowing in some of these contexts. I mean, in ways, you're almost portrayed as almost like a sort of a Socrates walking around information industries asking questions and sort of throwing people off their game. And maybe along those lines, I'm just wondering, the different reactions that you get. Do you think that those kinds of reactions are people who understand, how much of this is there are clear rules that these people are following and they're just simply abiding by the rules and not trying to rock the boat? How much it is it a kind of bureaucratic inertia where there's not clear rules, but this is the way it's been done always? And so you ask the question, well, why don't you sit on the meeting? They say, I never thought of that. And how much of it is simply people who actually are doing this in bad faith? That's really not a false consciousness. That's more of somebody who really doesn't care about privacy. They're concerned more about developing a great product, and they'll pay lip service to privacy, but really don't care about privacy outcomes.
Yeah, that's a really good question. Villains like, Mr. Burns type villains who are, sitting there in their offices, tenting their fingers and laughing at harming people. Those are true. They are truer in fiction and in cartoons and rarer in real life. I mean, villains certainly exist. There are plenty of people that I met who don't care at all about privacy, and they're all there just to do whatever their client says or to make profit. But that doesn't tell the whole story. But to directly answer your question, it's obviously a combination. What I think was much more interesting, though, than just saying big tech doesn't care about privacy. I mean, we all know, we can all point to these kind of stories. But the real interesting story is how a company turns someone who calls themselves a privacy advocate into something they don't realize they're doing something else. That's, I think, much more interesting to me and a much more interesting story. But obviously it's a combination. So there's always going to be corporate inertia that prevents new ideas from coming through, but it's also a product of choices that a company makes that are geared toward profit that have anti-privacy effects. So there isn't someone sitting in the back of the room saying, how can I destroy privacy today? They're sitting in the back of the room and saying, how can I extract the most profit from these people? And part of the result is also anti-privacy. So an example of this, some large companies, this is true even in small companies, a given product, like not just talking like a phone, but even an app, right? It's not designed by one person. It's designed by usually several engineering teams that do parts of it, and then things come together. That's why there's a product manager. One of the things that particularly at medium and large size companies do is they'll separate a product into lots of different pieces, and they will assign individual pieces to very small engineering teams. And they do that because it's efficient. Even we can look at the organizational literature and know that it's efficient to have a smaller team than a larger team. That's fine. The effect of that, though, is that you have less representation on each of the teams, right? So the smaller the team, the less likely you're to have representation of a minority or marginalized population, especially in a company where those people are few and far between. Also, the fewer people you have on a given team, the more work that they have, therefore they're unable to see beyond the particular work that they're doing. And then on top of that, in order to extract as much work as possible from that engineering team, they will often keep those engineering teams ignorant of what the other teams are doing, as if to say, don't focus on anything else, do what you're doing. But what that does is, at the same time that it amplifies engineers and other workers' kind of territoriality or turf, like this is what I'm doing, this is my job, it makes them unable to say, well, I spotted a privacy issue, but I'm supposed to focus on this. Is there someone else doing that? And then the product manager will say, don't worry about that, right? This is your job, right? Focus on this. It allows people to say, well, someone else is supposed to be doing that. I can't do anything about it. Now, that's not false consciousness. That is being hobbled. That's being cut off at the knees. So it's a combination of choices that management makes, some of which are geared toward profit, some of which are geared toward being to extracting data and being anti-privacy, some of which are geared toward doing what they think is actually right, but because of their willful blindness or because of management's skewed vision of what privacy is, they only focus on notice and choice, right? So I'm always very skeptical when I meet an executive who says, oh yeah, I read the privacy literature. I go to the Privacy Law Scholars Conference like John and I do. And yet every single piece of work that they assign to their privacy team is all about transparency, notice, and choice. And if you actually read the literature, you would know that that would be different. So something else is going on. So that's a very long way of saying, you're absolutely right. It's a combination of a lot of these things, but part of the story is not just that corporate organizations are slow or corporate organizations are geared toward profit. It's that showing these exact strategies is that all of those strategies that companies use to just do what they've always been doing or to extract profit are also habituating people into doing anti-privacy work, such that maybe if people knew that that was happening, they would have raised consciousness about their complicity.
I think that's fantastic. And I think, part of the great contributions of this book, it's sort of solving a bit of a mystery that I've seen in others, right? And I'm sure people who have dedicated a lot of their professional lives to advocating for privacy, working often in civil society. They move and join Facebook, they move and join a technology company, and you're thinking, oh, this person's great, they're really going to make some change, and then nothing changes, and they're still with the company. And there's so many examples.
Yeah, I don't begrudge anyone who needs to pay back loans, right? I don't begrudge anyone who needs to make $1 because civil society, they can't pay as much as a year of Facebook's, having Facebook stock. But what I do have a problem with is someone saying, companies only hire me because they care about privacy, or I'm really going to hold this company accountable, and yet nothing changes, right? There are tons of people who bloviate on Twitter about hire me because I'm focused on privacy, or I only go to companies that care about privacy, and then they go work for a company that gives them 6 figures plus stock options, and then they come out with an app or a pair of glasses that is taking pictures wherever you go, right? So I don't put much stock in those people, and I think that even if they may think that they care about privacy, they're either doing so incompletely, or they are just or they're just so willfully blind. But that is not to say that people shouldn't, or that it's bad. It's always bad to work for these companies. Like, I'm not passing judgment on people who go work for a company. We all need to pay back loans. I worked for a big Wall Street law firm, and they were awful, awful people. But I need to pay back loans. I'm still paying back my loans. So, but there's a very different thing between doing that and then claiming that you're going to change things, and then you don't, right? So just admit that you're going for the money, and then be honest about it, as opposed to claiming that you're some beacon of hope.
I think that's right. I mean, I have very good friends who have made that move, and they're fighting the good fight on the inside, but it's a struggle. They're doing their best in the circumstances, and they're not the ones doing the bloviating. But actually, this reminds me almost like sort of a labor extraction process going on, which brings me back to an earlier concept that you mentioned about data extraction. And maybe this leads to sort of another question. I guess the industry that you're focusing on, the information industry, or as Tim Wu would say, information empires. But the focus of this industry is information. But that industry, through monopolies and expansion, is moving out and expanding and covering new technologies. So think about emerging technologies. And this is this question is sort of a shout out to some of my students from my emerging technologies law policy governance class out there. So maybe before I get into asking you a little bit more about data extraction and that concept and how it ties into Shoshana's and Professor Zubov's and Professor Cohen's work, what is the role of emerging technologies in the privacy discourse, and compliance, and the design that you're talking about, AI, machine learning. How does these new technologies, or maybe not new, but these emerging technologies, how do they play out in the story that you're telling?
So it's a great question, and it highlights the central and foundational role that data collection plays in informational capitalism generally. So you can't have an artificial intelligence-based product that isn't trained on data, right? You can't have let's talk about what they claim first, because there's a lot of difference between what these companies claim their AI does and what it actually does. But machine learning systems depend on training data. Artificial intelligence products, anything ranging from the Facebook news feed to facial recognition, like you need data in order to do these. It's a form of data processing. It's a form of extracting profit from the data that you've created. So at its foundation, if we're worried about these products, which many scholars and many activists are, whether it's algorithms of oppression, or if it's or whether it's technologies that invade our sexual privacy, or whether it's technologies that are used to subordinate Black, Asian populations, women, queer people, and so forth. The foundation of all of that is the collection and the lawful connection and use and processing of data. So what this means is that the laws we pass and the systems we have in place that govern the collection and processing of data are the first, they are the tools, they're the first and perhaps the strongest tools that could rein in or limit the negative effects of all the things that we create that are based on that data. So if we're concerned about discrimination in algorithms, we should attack the data. We should attack the willy-nilly and Wild West world in which these companies collect data in order to train their discriminatory algorithms. We should be worried about laws that are proceduralist, that merely legitimize the collection of data as long as you fill out some piece of paper, because then you can go and use it for discriminatory purposes. So when we think about emerging technologies and also emerging industries, health is a good example. When we think about emerging industries, it all comes back to the ability to collect and use data for profit-making purposes.
Great. So I think that leads in nicely to my next question. And so when you talk about data collection and the legitimation of it, data extraction, and it's clear from this book that your work is influenced by Professor Cohen, Julie Cohen, and her fascinating, incredibly important work in information capitalism, Professor Shoshana Zuboff and her work on surveillance capitalism. How does your work build on their insights, and maybe a little bit about what you're doing differently, maybe with this book project?
Yeah, so I see Industry Unbound as the explanation for how informational capitalism works and is sustained and is maintained. Like, economic systems don't build products. Economic systems do not write policies. They require people, they require foot soldiers, they require people, either those evil Mr. Burns types, or they require people who have bought in, they require people who are pushing back, and they also require foot soldiers. So this book describes how exactly a system of informational capitalism persists in a world where people are claiming that they're privacy advocates and they're changing things on the inside, and where we have all this privacy law and nothing seems to be changing. So I see it very much as almost like a practical explanation, or an on-the-ground explanation that shows how right and how pervasive Julie Cohen's theory in her book Between Truth and Power really is. In terms of its relationship to Shoshana Zuboff's Age of Informational Capitalism, the real weakness of the age of surveillance capitalism is that it presumes incorrectly, as Julie's book shows, that the law was a bystander in the process of the commodification of human existence. And it's not. Julie Cohen's book, Between Truth and Power, which you should all read and get and read, it describes the ways in which law was manipulated and used and created the economic system in kind of a law and political economy and critical theory way, created the economic system or was manipulated by opportunistic actors in order to create the world in which we exist now, where technology companies are essentially immune from almost all forms of accountability. We wouldn't be living in a world that we are in now without their opportunistic use of the law. So Shoshana Zuboff's contributions about talking about, sorry, I'm outside, there's like a bug that's now like really enjoying me. Shoshana Zuboff's contributions about not just about the commodification of individual life, but of all of our experiences, but also the manipulation of other people, that's of course there. And there are tons of scholars that have written about and discussed that. But this is really I think the practical vision or the next step in between truth and power, as opposed to surveillance capitalism, which is essentially devoid of law.
Yeah, and that's, I think, first of all, I couldn't agree more. I mean, I think one of the challenges of Shoshana's work, because she marginalizes the role of the law, that once you get into understanding how pervasive the system of, or the forces of surveillance capitalism is, unless you look at the law and understand its role in facilitating and enabling surveillance information capitalism, it's difficult to understand how you get outside of it, how you can change things, how to move beyond it. And in fact, I think there's one point in the book where she even says the concept of social conformity may not have any utility because you can't get outside of it, that it presumes the social norms that you can step outside the social norms and critique from some outward standpoint as to, this is socially conform behavior and this is not.
Yeah, what do we can't? Like what?
Yeah,
like, that's
exactly.
not like, yeah, that's not really happening.
Exactly, and that's where I think exactly Julie's work provides an essential contribution about the role of law. And then we can start to imagine the law and policy and regulatory agencies in a different way to solve some of the problems that she documents and that now you have documented in the context of privacy and information industry. So I think naturally my question is, in light of the story that you've told, what you've documented, the challenges with these coercive co-opting practices of industry, what are your thoughts on liberating privacy from these coercive co-opting practices, this false consciousness that you've been talking about?
Yeah, I mean, that's the ultimate question. I'll start first with just a very brief sentence or two on the inadequacy of current proposals, which I think we've been getting at, right? Like I have an essay in the UC Davis Law Review and a larger paper in the California Law Review about, what's wrong with current proposals, and that they're all pretty much proceduralist. These privacy impact assessments, these records, these audits or assessments, and then about individual rights, which are never going to affect any material way a problem that's really a social problem about individual data, people's data affecting everyone else. So, all the current proposals are not the way around. They are, in fact, legitimizing the current system. And I know there are lots of scholars that I very much respect and love and are friends with, I'm friends with, that are supportive of these kind of proposals, but I'm just very skeptical of them, and I describe a lot of that in my work. So what would be emancipatory or liberatory privacy law? And first, let me say, I'm not sure yet. That's like the next project, right? And even we're books, like for any future academic here, like books are always works in progress too. Everything is, your whole career is. So a couple of things that we need to think about as we all together think about what liberatory privacy law might be. One is we have to get outside the limiting framework of just data protection. If we want to fix the subordinating or eliminate the subordinating capacities of informational capitalism or rise above them, we can't just think about data. We have to think about competition, right? Obviously, but even go further. We need to think about labor, right? Labor protections for gig workers all the way up to data researchers inside companies. If we had strong labor protections that allowed for independence and unions that protected the jobs of researchers inside technology companies like Timnit Gebru and others, they wouldn't have been fired the moment they wanted to publish a paper that challenged Google's bottom line. If we had laws that required companies that prevented companies from hoarding all the raw data that we need in order to study and hold these companies accountable, then we might not have the same concerns or same need from a data restriction or data restrictions type law, because we would be able to hold them accountable in different ways. Even go further afield from labor and transparency or trade secrets and other types of legal systems. What about thinking about environmental protections? It has been a little bit of a joke for decades, but the internet does require physical infrastructure. When companies say that they're transferring or using transferring information in the cloud, obviously we all know it's not literally in the clouds, right? They're transferring information between Canada and Europe and Africa and the United States and the United States and Europe through physical infrastructures that, when built, are destroying delicate ecosystems. So if we had environmental protections that would constrain what companies can do in these delicate ecosystems, then again, we might not put all of our eggs in one single basket, meaning that we might be able to ask more of less of a law. Like, we don't need data protection law to solve the whole problem. We should also think about licensing regimes that put public governance in charge of data uses. That's something that is being discussed only in academic circles as of now, not even at the European Union, but definitely proposes a more robust public governance version of data processing. And this is, of course, in addition to far more robust sums of money that we send to our actual agencies of public governance, such that, one of the things, and this is an argument I make in a piece coming out in the California Law Review, one of the things that makes us so willing, or makes legislatures so willing or real forced to follow in this path-dependent way of legislation, which we're all procedure and we're relying on audits and stuff like that, which Julie Cohen called in her book as tools on the periphery of the regulatory state. The reason why we do that is because the last 50 years of neoliberal and conservative governance have hollowed out institutions. And we have become habituated into thinking that, well, that's what governance is, meaning that, well, we don't need to give the FTC another $1 billion to have their own audits, because companies' auditors are right there to help them to fill in the gap. So when companies' auditors are right there to fill in the gap, it gets us habituated into thinking, well, we don't need to pay for our own auditors. But of course, as I describe in the book, and as Megan Gray described in a research piece of her own when she was at Stanford, audits are less than silly. They are pointless documents in many cases, where, and here's just one final story to answer this question. I actually saw some of these audits, which are actually called assessments. And these aren't, when you and I think of audits, we think of some person coming in, independent, paid by someone else, coming in, sitting in a conference room, going through all the papers and doing their own third-party independent investigation. But in fact, these assessments that these companies send to the FTC, including European data protection agencies, go something like this. There's a question on it that says, are you in compliance with section 5.2 of the FTC consent decree of 2012, which requires X? And then the answer is see Exhibit I. And then when you go to Exhibit I, it's a letter, a one-sentence letter from the executive saying, I attest that we are in compliance with section 5.2 of the 2012 consent decree, period, sign, and that's it. That's what passes for public governance in this world. And that is that, I mean, I want to use curse words. I want to swear. I'm so frustrated by something like that. But I realize that this is being recorded, so I probably shouldn't.
That's good. I mean, this is part of the story that you tell, these entrenched practices inside of companies and outside of companies and regulatory practices. Everyone is sort of following along, doing business as usual, and it has to change in order to, I guess, liberate privacy, as you say. I actually think that that answer is a nice moment to turn over to Q&A and take some questions from our audience. And I see, I'm starting at the top here, I see there's a question from Andrew M. Monty. And Andrew A. Monty. So Andrew asks, how does the book fit, and I know you do talk about this in the book, how does your book fit with scholarship on psychological manipulation campaigns, i.e. private data used to manipulate attitudes and behavior? For example, books on Cambridge Analytica.
Yeah, so great question, and thank you. That literature is canonical, and the part that I rely on, though, is the way in which, so I rely on it in several ways. So part of the book, or at least the core of the book, is about the manipulation and the co-optation of individual people and their psychological element on that. And for that, I rely on the work of work on habit. I rely on work on organizational structures, on the way on work by people like Lauren Edelman and others in the sociology of organizations that talk about how organizations affect the behavior of individuals, but also there's some psychology work on developing people's assessment of themselves, like how they develop their own sense of self at work. There are, and of course, there's tons of other use of social science in the book, because I'm also setting it in a context of how we interpret privacy law, i.e. like the stuff I was saying before about how working on privacy notices and transparency is not helpful when it comes to privacy. In order to establish that, I talk about all the psychological literature that shows how pointless that actually is and how unable we are to take advantage of those choices and those options.
That's fantastic. I've got a question from one of our great graduate students here at Osgood, Jake Okechukwu. Jake asked, he says, absolutely brilliant work, Professor Waldman. He asks, if in your research you found any nuance with privacy breaches that disproportionately affected minorities like LGBTQ plus folks or Black communities. And maybe an additional context could be how some of the entrenched practices that you saw might impact those communities outside of the companies as well.
Yeah, there's a lot of literature out there, and I've written a little bit about it. How almost all privacy invasions are the burdens of them are borne unequally and more by those most marginalized in our society. I do some work in the queer community, as does people like Scott Skinner Thompson. The disproportionate burdens faced by those who identify as Black or African American. There's work by Sophia Noble, Ruha Benjamin, and so many others. So that is definitely the case. And specifically, there are lots of examples of this. So while this book was not specifically focused on those effects, one of the things that I do focus on is what goes on inside the company as a result of the lack of representation. So Jake, I'm certainly concerned about the effects, but this particular project was not about that. But one of the reasons why privacy is not always privileged or doesn't always gain a foothold in the design process is because much of privacy design is so dominated by people of privilege who don't realize the burdens borne by marginalized populations when they have to provide information, or when location data is shared, or when an app shares your HIV status with a marketing company, right? Which is a significant concern to all people, particularly queer people. So one of the things I talk about is the trap of companies staffing engineering teams with all white dudes, straight white dudes, and the trap of putting almost like gerrymandering, where you pack all the women of color, engineers or workers, into one team focusing on one product, and that's fine, but that's fine for that product. But that's also a limiting force, right? You want more voices as well, and also it eliminates their voice on other products, right? So companies have lots of strategies for allowing them to say, we're hiring a lot of Black women, like Twitter has now developed. Twitter's actually among bad actors, they're not the worst, and they've hired quite a few women and Black women engineers. But they're all working on, a lot of them are working on similar products. And in other companies, there are just so few of them. So I talk about the gender trap, the lack of respect for women in the engineering teams. I talk about the race trap, in that there are very few persons of color in these engineering programs. There are so few that there are more people who identify as Black than there are people who identify as Latinx, right? And we all know how few and Black engineers there are, right? So that I talk about in the context of the limitations in the design process.
I think a great sort of example of what you're talking about, Ari, is the recent fallout from Google's AI ethics team, which had some fantastic people as part of the team. But at least part of that story is exactly what you're talking about, where they were siloed off, where they attempted to have real impact on products and what engineers were doing. They were either siloed off, ordered not to be involved, or simply terminated in certain cases, right?
And then there's another strategy, sorry to interrupt, but another strategy that companies use, even like short of firing them, is like they'll hire a privacy engineer and brag about it, but then limit that privacy engineer's ability to have any impact on design by using them as just auditors of the code that other people have written at the end of the process. And in real life, I mean, theoretically, someone could change the code at the end, but in real life, after all the money and all the time spent developing this product, how likely is it that someone at the end of the process is going to go through hundreds of thousands of lines of code, and even if they do, and even if they spot issues, that the company is going to be willing to go back to the drawing board and redo it? It's so unlikely. But the genius, the evil genius of that strategy is that, well, they totally hired a privacy engineer, and that privacy engineer did audit the code, and that's the limit of what they said they were going to do. And of course they did that, but they didn't change any practices as a result.
Yeah, they're far more likely to show that sort of last person raising challenges and blocking, this is not compliant with our vision for AI ethics or privacy. That person's going to be shown the door far more likely than they're going to hold up and redesign that product from the ground up. I think that's absolutely right. All right, let me go back to questions. Here's one from one of my great colleagues, Professor Karis Craig. Professor Craig says, fundamentally, the book seems to be about the nature of law and its relationship to capitalism, albeit now surveillance capitalism. Much of what you say, false consciousness, invokes a Marxist or even critical legal studies, inspired by critical legal studies critique, and of course, Shoshana's and Julie's work, that is, law as part of social structure that sustains economic relations of capitalism. Yet you also talk about corporate actors as co-opting law. Does this idea of co-optation assume law's relative autonomy or even its original purity? Do you think law has or could have such autonomy from capital, or are privacy law solutions only ever and inevitably ways of permitting data extraction and economic exploitation? And if so, where does that leave us or your next book project?
Great question. The quick answer is no, there is no such thing as law, some autonomous product. Law is a social construction of lots of different forces in society. Of course, the idea of co-opting law, though, is part of what I guess you consider as kind of a vicious cycle. So these companies influence the law, the social, these limitations of language, the institutional obligations, for the selfish forces, the social facts of legislature, of lawmaking, like all of and the political economy in which lawmaking exists, like all of those forces, including lobbying against law, they create law. But what then these companies do is they're not satisfied by just limiting or creating law or affecting law through the lobbying process, they go further, and then they take the law that was socially constructed from the beginning and they make it even weaker. They take a law that creates compliance structures, and then they turn them into checkbox structures. They take a law that required individuals to do certain work, and they co-opt those individuals. So it's a great question, and I certainly did not mean to suggest that law is some autonomous object or autonomous entity that is then manipulated as and period, end of story, but it's part of this ongoing system that erodes the opportunities for any effect, any limitation or any accountability. But in the end, like that's part of why, I mean, that's part of why this is so difficult if you're talking about like the next project. When Daniel Solove, who's a professor at George Washington University School of Law, who he is the dean, lowercase d, of the privacy field in the United States. He has like the most citations of any privacy law scholar and a really great mentor. And one of the things he said about my book was that, you know, your critique is so solid and it is so powerful, and it is so good. I don't say this as a brag because it's actually a critique. It's so good that there's no outlet, right? There's nothing. If your reader believes what you're saying, you're lost, because there's nothing that you can do about it. Because as you note, you know, law is a social construction anyway, so we're not going to get out of the cycle, such that I don't know what the answer is, other than burning it all down and building it back up again. But really, I'm not sure we're going to get to the kind of world that we want short of nationalizing these industries, right? And I know that's not happening tomorrow. But in the line of inspired by people like Andre Gorz, the socialist philosopher, who talked a lot about non-reformist reforms. In the spirit of Andre Gorz, like the things that we do change before we get to that ultimate goal has to always raise our consciousness about our subordination, including the consciousness of the workers inside these companies.
Okay, that's great. I have another question here. This is from one of my students, Eugenia. She asked, and I think a bit of maybe a generational question or a way of a context to this. So she says, you know, it's clear that various people in various communities have different needs for privacy. Some people want no digital footprint at all, while others are happy to knowingly sell personal data in exchange for targeted advertising. Is it possible that in a modern world, some people have grown up knowing that the concept of privacy might not exist? And if so, is it possible that those companies care little about privacy because society in general cares little, something privacy law or privacy protective law overlooks? And maybe underlying is something that, you know, we've seen in privacy literature, this notion of, you know, digital natives, right? That there's something, do young people, because they've grown up with social media, not care? And I know there's research out there that discounts these assumptions, but let me hand it over to you.
Yeah. Well, that's right. I mean, the question is so steeped in extractive ideology from the information industry that I hesitate to even respond to it. Like, it is, as you introduced, John, it is simply not the case. There is zero evidence that just because you're a digital native, you don't care about privacy. There is, in fact, evidence from, you know, people who study children, to people who study adolescents, to people who study people of my generation. I'm 41. I was of the generation that spanned the computer revolution. So I wrote things by hand, and then when I got to college, I mean, I think I had one of those little Apple computers, right? And then so my generation was the one that spanned it. And studies of all of these age groups are concerned about privacy. In fact, young people are so concerned that they wrap themselves into pretzels trying to navigate privacy wizards and privacy centers on apps, of course, not everyone, but lots of them do, in order to share, right? That's part of the basis of my first book, Privacy is Trust. Like the idea that people want to share, and people want to share within structures of privacy that allow them to share. And that's one of the boons, one of the benefits of privacy. So I hesitate to even entertain a question that has at its presumption the idea that people don't, especially young people or as a generational thing, don't care about privacy. It's simply not true. It is a talking point. It is a corporate talking point. And if they use that to justify their lack of focus on privacy inside their companies, well, we have to call them out on that too.
Great. Okay, so I think this is what Neil Richards says, Ari lobbing some bombs as part of the talk. Great. So I've got another question. Some people are seconding the question. This is actually Stony Baker, one of my students. So Stony asks, and maybe this leads nicely on from your mentioning your earlier fantastic book, Privacy as Trust. What are your views on data trusts? Are data trusts part of the solution, or are they part of the problem, or is it something else?
So there are a couple of different definitions of a data trust. I mean, before I answer, and maybe the person who asked this question can clarify, do you mean about protecting data as a thing of property and being able to extract value from data as a form of property from the individual?
Stony, I don't know if she heard your question. How about this?
Okay.
Ari? Yeah, go ahead.
Yeah, so I don't, the reason why I say that there are a lot of definitions of data trust is because that term is used in so many different ways, right? It's used in terms of establishing relationships. It's used in terms of a legal structure as a device. Like, it's used in so many different ways. So I'm not exactly sure the thrust of the goal of the question. But if it is focusing on, I think I see a rather as what is supported by algorithm watch out of Germany. So I'm
not sure.
I don't understand that sentence. So the concern, of course, with treating data as property, and again, I'm sorry if this is not the question that is asked, any device that treats data as property makes data a market good. Right? It makes data and our privacy a market good, which is exactly what industry wants, because then they can buy it from teenagers for $5. And our inability to, and here's some social science, our inability to assess the potential future risks. We are hyperbolic discounters. We don't, or hypobolic discounters. We don't actually adequately threaten the potential future risks of harm for something that we don't conceptualize now. So we're never going to be able to adequately value our data, and it's also going to take advantage of the poor and those more marginalized in society, especially in the lower socioeconomic classes, who know that $5 means a whole lot more than for rich people. So I don't want to live in a world where rich people can buy privacy and everyone else is screwed, but that's basically the world that we live in now. But if you think about data trust in terms of like a licensing regime where you have an entity, a nonprofit entity that would only allow companies to use our data if they license it from us. It's almost like a talk or almost like a tax. That's much more interesting because that's not property based. That's public governance. That's democratic governance. So there are lots of different ways that this term has been used. And if it's truly a form of democratic governance, that has potential, but of course the devils are going to be in the details. The governance has to be truly democratic in that it has to achieve not just limitations on what companies can do, not just governing access, but it has to limit what companies can do, and it has to adopt an anti-subordination principle as well.
Great. Okay. I've moved back up the chat a bit and I see a question from Nick, one of my students, Agostino. He's asking us a more specific question about the CCPA, the California Consumer Protection Act, and the GDPR. But since you mentioned the GDPR earlier and the California Consumer Protection Act that comes up in your book, it would be great to actually have your thoughts on both of those statutes. You mentioned the GDPR earlier, and it's right. It's often described as being this sort of generational, most strict example of data protection reforms. And in Canada, as you noted earlier, we're in the process of going through privacy reforms, or at least the process ourselves, and looming large in those conversations and in those debates is the GDPR. Almost often held up as a model. It's the first statute that's often mentioned, or the first example of a regulatory model. And of course, California's Consumer Protection Act. Are these models that Canada should be following, or they're just more, to borrow Bruce Schneier's metaphor, more privacy theater?
Yeah, so the answer to the question is no, no one should follow these examples. They are, if they ever were good ideas, they are already outdated. And there are several reasons why. So European legislators and proponents and scholars who are proponents of the GDPR can talk all about how it's a human rights-based law. I mean, sure, data protection and privacy are in the European Union's founding documents now, latest amendment in 2009. But I don't see any human rights in that law. I see procedure in that law. So chiefly, so you can say it's human rights all you want, but it's a procedure-based law. The CCPA is even worse. Like, the CCPA barely even has the procedure. It only really has those individual rights. And again, like we were talking about before, no one is in the position to exercise these rights. And even if we do, any individual exercising these rights is going to have an immaterial effect on informational capitalism and its extractive and oppressive nature anyway. So these are not models for us to follow. And in fact, they are precisely the models that companies want us to follow. Because despite all of the performative hemming and hawing and objections to the GDPR and the CCPA that these companies have levied for years, right? The practices that are codified in the GDPR, the compliance practices, were practices that these companies have been doing for decades. The individual rights have been part of the privacy discourse since the 1970s. None of this was new. They made such a stink about it because they wanted us to think like this was an anti-corporate program, when all of the practices actually trickled up from corporate behavior. It's what we call endogeneity, the endogenous nature of law. It didn't just come from our practices, it came from their practices. GDPR and the CCPA, they're gifts to industry, because if all you do is require someone to fill out a form before they process our data in a discriminatory and manipulative way, they're going to fill out that form and then they're just going to go ahead and do whatever they wanted to. But now they're going to do it having legitimized what they were doing before.
Great. I've got a question from one of my colleagues, Professor Dan Priel, and he asked, and I think maybe there's a part of this is similar to Dan's question that about your work your argument being so comprehensive. How do we step outside of it? But this is what Dan says. He says, maybe the false consciousness that you talk about in the book is actually far wider than you suggest. We come to these talks, like the one you're giving, about the loss of privacy, and we shake our heads about these new developments. And then the moment the talk is over, we go back to check our Gmail accounts, Facebook, Twitter, and not ignoring other explanations, sociological, psychological, for why privacy people who work at Google, Facebook, and Twitter behave the way they do. But maybe part of the story is that in the end, they are just like the rest of us. And maybe I could add maybe one sort of coda or footnote to Dan's provocative question. is that maybe stepping back, Ari, do you see any changes happening today that you would see consistent with the systematic structural change that you talk about that's necessary in the book? And I wanted to sort of flag, Lena Khan being appointed as chair of the FTC, really has done really innovative work on antitrust. Alvaro Badillo just recently, we both know from the Georgetown Law Center, recently appointed to the FTC. Are these examples of some of the systemic structural change? Or is it something that is just going to reify the structures that you set out in the book?
So in reverse, Commissioner Khan and soon to be Commissioner Bedoya, they're great appointments, the best appointments to the FTC in quite literally forever since the FTC began. That isn't structural change though, because it's within the current structure, but they may have, I think have the ability to use the current structures better than people who came before. The FTC has been awash with neoliberals since before the Obama administration. Like, we had people who were Democratic appointees who quite literally said the job of the FTC is to partner with industry to advance innovation. That is bullshit. It is not the job of the FTC to partner with industry to advance innovation. The FTC is a counterweight to corporate power. And I think Commissioner Khan and soon to be Commissioner Bedoya, I think are really the first ones that understand that. Rebecca Slaughter, Commissioner Slaughter as well. But to your colleague's question about, does this false consciousness spread further? The answer is yes. This book, of course, is about inside these companies. And I've written about the false consciousness or the habituation of individuals into the system as well, where that's much more closely to the Gramscian idea of false consciousness. And for this, I also recommend the work of Gordon Hull, who's a philosopher who has written on privacy. He described the system of privacy law that we have now, notice and choice, et cetera, as a technique, a Foucaultian technique of power. It's a victory in the sense. It doesn't actually protect privacy, but that's not its point. Its point was to make us think and habituate us into thinking that clicking agree, changing toggles, that is privacy law. We're all like that, right? So again, we cannot and should not fall back on this idea that we're just all in the tech world and we all are just so used to it and we all don't care about privacy. If that was underlying your question, I just vehemently disagree. And it's a presumption that we all need to push back on and simply resist. But if we're talking about habituation into this kind of false consciousness, then you're absolutely right. It does affect all of us because we constantly are clicking agree and we're constantly exercising private or following in this individualized privacy law system, which makes us think, well, this is what privacy law is.
Great, and actually, I think a nice follow-up question comes from student Warren Urquhart. He's also in my class. Warren asks, do you see the policy change that you're talking about, Ari? Do you see the policy change happening from the top down, i.e. academics and regulators, to assume our sort of egotistical role as academics, do we have a special role to play here, or from the bottom up, grassroots, et cetera, pressure? I ask because the companies that perpetuate these issues and their products are so ingrained in society. Traditionally, any systemic change has to come from grassroots pressure. Is there hope for short-term change in America if most of these conversations are just happening amongst law professors and law students and other in academia? What are the grassroots organizations bringing public awareness to the issue, or
Great
even
question.
are there?
Great question. So change has to come from the ground. there is no way the change given by elites can raise the consciousness of the people about their subordination. Change has to come from the ground. And although you described academics as coming from the top, academics can play a role in building ideas that are taken by activists and advocates on the ground. So what I think we really need in a movement for privacy, and this may be my next privacy project once I finish a misinformation project, but what I think we need in order to create a real movement on the ground for privacy is that privacy has to be part of the agendas for civil rights organizations. So like for those queer people in the audience, you may know that the Human Rights Campaign, which is the largest, they call themselves the largest LGBT advocacy group in the United States. They're looking for a new executive director or new president because of significant moral failings of its former one. And if I were to have that job, I want privacy and civil rights to be part of the gay agenda, right? They were already doing this, right? Data for Black Lives makes privacy and data issues and algorithmic fairness issues part of the civil rights agenda for those who identify as Black or African American. The NAACP Legal Defense Fund is going to have a new president, new executive director stepping up, and privacy and data protection and algorithmic fairness need to be part of their agenda, right? So, queer organizations, the organizations that I just know best just because I identify as queer, these organizations spend a lot of time and money on marriage equality and non-discrimination, and that's great. But the only way we're going to get these to be get data issues and such as part of a larger agenda is if civil rights organizations make it. So my vision is that let's learn from ACT UP, for example. How can we take what is probably the most successful grassroots movement in the last 100 years, the smallest and most successful grassroots movement in the last 100 years, and how can we take their lessons and translate that into something so different as privacy? Like, no one's dying here, like so many gay men died of AIDS, but how can we take the lessons of their activism and translate that into a real civil rights agenda for liberation from data-based oppression?
Okay, I mean we're getting close to the end. I mean, that's a
sounds
really
like a
nice
good place to stop.
Yeah. I actually think that's a really nice place to stop, and I'm conscious of the time constraints that we're putting on you. I know there's many more questions there. I'd love to throw them on, but I think we should wrap things there with that nice final question. Let me just say,
sorry to interrupt, but people who have additional questions, you don't hesitate to email, reach out. My email is very accessible on Northeastern's website. I look forward to continuing the conversation. Thank you so much, John, for inviting me and for facilitating this conversation, to all your students and your colleagues who took the time out of their very busy days to attend.
No problem at all. And thank you, Ari, for joining us and for this fascinating and timely conversation. I'd also like to thank the audience participants who joined, and students, grad students, and my emerging tech students alike. And of course, also thank Erica Robinson, who from Osgood's great communications team, to help put this event together. Thanks very much, Erica, and my online facilitator, Nojin, as well, for keeping track of things. Thanks very much, Ari, and I'll see my students in class next week. Professor Waldman, thank you so much.
Thank you, and see you at PLSC 2022.
Yes, absolutely.
All right, bye, thank you.